About half the cases we handle are more contested divorces. Those are divorces where the litigants don't reach agreement very early and instead need the intervention of the court system in order to reach a resolution. Now, these cases typically involve 4 distinct segments. The first segment of work in a contested case involves the case workup. This is where we put together the initial pleadings in the case and serve and file them. We have you complete an initial questionnaire and provide initial documentation to us so that we can adequately move forward and understand exactly what relief it is you're looking for. Following the service of the summons and petition, we will participate in what's called an initial case management conference. This is a first meeting with the judge on an informal basis to talk about the issues that are in controversy, and the court at that point might refer us to an early neutral evaluation. This is a process where the parties can go and meet with a court-appointed expert and try to settle the case relatively early. Well, if matters don't resolve at the early neutral stage, then we move into the next phase called discovery. This is a process where we're going to actually gather information from your spouse. We may do so formally or informally. And in addition, we may elect to schedule a motion for temporary relief. This is a hearing that would take place where the court would actually make a determination on a temporary basis of who's going to reside in the homestead, who's going to have temporary custody of the children, what sort of temporary alimony or child support awards are appropriate. Quite often, cases will settle following the entry of a temporary order because the parties have a little sneak peek into how the judge is kind of viewing the facts of the case. However, if the case has to continue, we will then actually engage in the next stage, which is kind of a position your case for settlement stage. We're going to attempt to work out matters either through mediation or some other form of alternative dispute resolution. If we're not able to work it out, the court will call us back in and we will participate in what's called a pre-trial conference, where we're going to try one last time to get the case settled with the assistance of the judge. If it doesn't settle, and we have to go to trial, then that is the next phase of the case. The 4th phase involves preparation for and actually trying the case. Now, the judge has 90 days to issue a written decision following the end of the trial, and if either party is dissatisfied with the outcome, they have an additional 60 days in which to file an appeal.